Alright, so for Module 2 case study, we're going to discuss the Fourth Amendment and search and seizure. In this case, we're going to talk about New Jersey versus TLO. The other case is going to be Vernia versus Acton. Right now, we're going to focus on New Jersey versus TLO, which took place in 1985. Now, the questions we're going to be asking are, well, first we're going to write a summary. We're going to write a summary of each of the cases. We're going to write a summary of New Jersey versus TLO and one of Vernia versus Acton. Now, these are each going to be 3 to 5 sentences long, so you're going to need 2 paragraphs for this to answer this question. So your entire case study for Module 2 should be 5 paragraphs, 1 for each question, but 2 paragraphs for the first question, which is asking for a summary of each case. And then the second question is asking, how are the cases similar to each other? In other words, why would the earlier case, which is TLO versus, or New Jersey versus TLO, which took place in '85, be a precedent in the decision for the other case, which is Vernia versus Acton, which took place in '95, so 10 years later. The other question is, what are the main arguments for each side in Vernia versus Acton? Now, we can't answer this one yet. After this video, we won't be able to answer that one because that'll be for the next video. What I do see a lot of students doing is they will give me the arguments for the New Jersey versus TLO case. That's not what the question is asking. The question is asking, what are the main arguments for each side in the Vernia versus Acton case? So just make sure you're giving the arguments for the school and for the Acton family. And make sure to include details that'll support their opinions. Which side in the Vernia versus Acton case had a stronger argument and why? This is where you get to give your opinion. Which one do you think has the stronger argument? There's not a right or wrong answer to this one. Okay. Again, you don't have to side with the majority opinion. It's just that. It's an opinion. You don't have to side with it. There are dissenting opinions, and you are allowed to have a dissenting opinion as well. So when you answer that last question, you can choose to be on the side of the Vernia School District or the Acton family. Now, however, whenever you do answer these questions, or whenever you do decide which one you are siding with, Vernia or Acton, make sure that you include some facts, include some evidence to support why you think that side had a stronger argument. Okay. So what happened in New Jersey versus TLO? Well, basically a high school student was arrested for possession of marijuana. She was suspected of smoking cigarettes in the bathroom, so when she was taken to the principal's office, the principal searched her purse to look for the cigarettes. When looking for the cigarettes, in plain view was also a bag of marijuana and a list of names of other students that owed her money. So these were confiscated and used as evidence against her when she was later arrested. She was charged with having possession of an illegal substance, while TLO moved to have the evidence suppressed. The evidence should be suppressed because there wasn't probable cause for the search of her purse. That's what the claim is. What happened next is it went to the Juvenile and Domestic Relations Court of New Jersey. They found her guilty. They found her guilty and sentenced her to 1 year of probation. Now, TLO appealed the decision. It went to the Appellate Division of the Superior Courts of New Jersey, and they affirmed the same decision of the lower court. However, when it was appealed to the New Jersey Supreme Court, they actually reversed the decision and said that the exclusionary rule applies to public school searches. So you may be asking yourself, what is the exclusionary rule? Well, the exclusionary rule, it comes from the Supreme Court in the case of Mapp versus Ohio. It states that evidence that was gained through unreasonable search and seizure, violating the Fourth Amendment, cannot be used against the defendant in a criminal proceeding. This also applies to self-incriminating statements. This comes from Miranda versus Arizona. You may be familiar with any cop show you've ever watched. When they arrest somebody, they say, "You have the right to remain silent. Anything you say can and will be used against you in the court of law." This is the Miranda rights that are read by the police officers when they arrest somebody, letting them know that they do not have to say anything. They do not have to answer incriminating questions. But after they've been read their Miranda rights and they are asked incriminating questions, those things can be used against them. If the Miranda rights are not read to them, then the exclusionary rule applies, and whatever they say will not be used against them. And the same applies for evidence that is found in an unlawful search, where probable cause was not present. Now, this rule does not apply in civil cases because there's not a crime. You're not being charged with a crime. It's a civil case, so it's different. So let's look at the issue. What is the issue? What happened here? Or what are we trying to figure out? We're trying to decide if the exclusionary rule should apply to searches conducted by school officials in public schools. That's what the Supreme Court is trying to determine. While the majority opinion, which was a 6-3 decision, sided with the school district. Justice White wrote the majority opinion stating that the search of TLO did not violate the Fourth Amendment. He's saying that the search was reasonable. Now we'll touch on that word reasonable in a minute. The principal observed circumstances that would lead a reasonable person to believe that TLO had cigarettes in her purse. And then when he conducted the search of her purse, within plain view were a list of names that owed money to TLO and a bag of marijuana, which would make him think that she was selling drugs in school, which she did admit to. So let's look at some of these key terms. Probable cause, which we've mentioned, and then there's that word again, reasonable suspicion. What is the difference? Okay, so there's three things that can allow someone to be searched. One is a search warrant. That's pretty cut and dry. That's plain and simple. If a judge or magistrate issues a search warrant, police can search your belongings, or your home, or your workplace, or your car, or whatever it is. There's a search warrant, so that's not something you can really argue. However, probable cause is something that's a little bit more subjective and is done in the field by the police officers. It's basically reasonable grounds to believe that a crime has been or is being committed. And this could lead to an arrest. And then later on, the evidence will be sorted out later after the arrest has taken place. Now, reasonable suspicion is basically just justifiable suspicion based on facts or circumstances that could basically lead to not necessarily an arrest, but being detained. Maybe stopping someone to investigate, see, okay, this doesn't seem right. Maybe there's something going on. Let me go ask this person some questions, detain them for a minute, and then you can do a search depending on like a stop and frisk or something like that. That's reasonable suspicion. Probable cause would be you pull somebody over and you smell alcohol. Okay, that's probable cause. Now, reasonable suspicion would be pulling them over because they were going too slow in the left lane. They were driving the speed limit and not driving with the flow of traffic. There may be suspicion to know, okay, there's something going on here. They're being a little too careful on the road. They're going the speed limit, but they're in the left lane. Okay, maybe there's something here. That's suspicion. They're just suspicious. So the concurring opinion. These are the justices that agreed with the majority's opinion. However, they wanted to emphasize a different point. So you had Justice Powell. Justice Powell emphasized that students within the school environment have a lesser expectation of privacy. So they don't have the same level of privacy as adults in the general public. Justice Blackmun, he stated that government has a heightened obligation to safeguard students whom it compels to attend school. So the schools have an obligation to keep them safe. So in order to do so, they may have to conduct searches if they believe that drugs are being sold at school. Now we'll get on to the dissenting opinion. Well, it's not necessarily just a dissenting opinion. This is a concurring and dissenting opinion because they agreed with part of what the majority opinion said, but they still disagreed in the verdict. Okay, so Justice Brennan and Justice Marshall here, they agreed that schools may generally search students without a search warrant. They don't need a search warrant to search a student. However, they believe that probable cause should be the standard for searching a student without a warrant, not reasonable suspicion. Because if you look at it, there's search warrant, then there's probable cause, and then reasonable suspicion. Reasonable suspicion is it's a lot more lenient. You can get away with searching someone without having a whole lot of evidence as to thinking, they may have committed a crime. Reasonable suspicion, if you articulate it a certain way, you can pretty much get away with searching, for almost any circumstances. So here's something to think about. Should students be afforded the same search and seizure standards as the general population? Or do you feel like Brennan and Marshall were onto something here? Should the standard for searching students be probable cause? Should there be some facts or circumstances that would lead somebody to believe that something is wrong or that they've committed a crime? Or should it just be some reasonable suspicion? I hope I was clear enough on the difference between the two. They really draw a fine line. It really depends on your perspective on what is probable cause, what's reasonable suspicion. But hopefully I was clear about that. So again, you're going to write 2 paragraphs summarizing each case, New Jersey versus TLO and Bronia versus Acton. Then you're going to relate the two to each other. How are they similar? Why is one a precedent for the other? And then in the last 2 questions, we're going to talk about Bronia versus Acton, which we'll cover in the next video. So I hope this was helpful, and just let me know if you have any questions.